The Supreme Court of Canada is sending the case back down for trial on manslaughter, not murder. So this is in some ways a good thing. For Cindy's family, there's no good answer here, because going back down to trial means that her mother and her daughters are going to have to relive what was a horror the first time. The decision of the court to send it down really stems from the fact that there were so many egregious errors at trial, and on behalf of the defense counsel, the Crown, and the judge. And really they all had to do with the idea that there is a part of the criminal code, section 276, but that part of the criminal code is intended to eliminate evidence that might be used to suggest that she was not worthy of belief in the first place, or that she would have consented. Responsibility lies on the trial judge to ensure that this happened, and it was a failure on his part to not do it, and it's also a failure on his part when she was called a prostitute and she was called Native so many times. These were collapsed together too, that he should have warned the jury. He should have given them some kind of instruction on how this shouldn't be taken into account. And he did none of this.
There is an obligation on all players within the court system and the criminal justice system to ensure that bias, prejudice, sexism, and racism do not form part of criminal trials. It is emblematic. And we heard from women across this country that when they encounter the criminal justice system, they are often reduced to their stereotypes, reduced to prejudice, and they do not get the justice that other Canadians get from the system.